Hey class, welcome to week 7 of administrative law. Today we are going to talk about agency rulemaking, the process by which agencies issue regulations. So on the screen you can see the EPA's headquarters on Pennsylvania Avenue in Washington, D.C. I'm using this image because we're going to discuss both EPA and Consumer Financial Protection Bureau regulations, and of those two agencies, the EPA has the nicer looking headquarters. So today we're going to talk about rulemaking, what it is, why we care about it, the process through which agencies issue those regulations, and we're going to also talk a little bit towards the end about enforcement, including the seemingly never-ending saga of the FDA's new cigarette graphic warning labels. Okay, so let us jump in and start to learn about rulemaking. So we can start by asking, what is a rule? So as I've mentioned, rules are also called regulations. I will almost always call them regulations. That's my preferred term. That's the term that most attorneys use. However, it is easier to talk about the rulemaking process rather than the process of promulgating regulations. So rulemaking it is for the process, and if the word rule slips through in my lecture, just know that I am talking about regulations. So the Administrative Procedure Act, the APA, defines a regulation as whole or part of an agency statement of general or particular applicability and future effect designed to implement, interpret, or prescribe law or policy as it relates to the agency. So the main thing is that regulations are supposed to have a future effect of compliance. They direct future conduct or create a procedure to be used moving forward. Like our laws, regulations cannot be ex post facto. They cannot look backwards. They can't retroactively change the legal consequences of past actions. Regulations look to the future. They are also directed at large groups and or overarching policy issues. So that makes regulations different from adjudications, which are hearings for individual people about a specific set of facts. So the definition that is on the slide is really the definition for a legislative rule, the type of regulation that is our main focus in this class. And these are the regulations that have the force of law. Now, just be aware that there are also interpretive rules, which are usually found in guidance documents and agency manuals. And interpretive rules tell the public how an agency, for instance, interprets its mission, but they do not have the force of law. So keep in mind that you have already seen many of these legislative rules because we have gone over portions of the CFR. And as its name implies, the Code of Federal Regulations is packed full of regulations. So just for example, Title 12 in the CFR is Banks and Banking. It contains the Consumer Financial Protection Bureau's regulations. Title 40 is called Protection of the Environment, and it contains the EPA's regulations. So when people talk about regulations or lack thereof, they're usually talking about these legislative rules, the types of regs that fill the gaps, that Congress leaves in its statutes. And these are the types of regulations that we're concerned with in this class. Now, these gap-filling regulations, they can be procedural or substantive, and both types carry the force of law. Procedural regulations, as the name implies, establish and implement a process by which the agency plans to carry out its statutory mandate. And agencies have the implied authority to issue procedural regulations, so it is very difficult to challenge an agency's decision to issue one of those. The substantive gap-filling regulations, those operate just like laws. They reach into our lives by requiring specific actions or prohibiting specific actions or imposing penalties for some sort of non-compliance. And Congress has to delegate authority to agencies to create these substantive gap-filling regulations. But that authorization can be implied. Congress does not have to specifically or explicitly tell the agency to create regulations. Because these substantive regulations impact our lives, they are easier to challenge in court. So we'll actually see this towards the end of the lecture with the ongoing FDA saga. We can challenge the agency's inaction when it comes to these regulations. Now, as you might recall from that case of GM versus FERC, it's very difficult to challenge agency inaction. But if Congress tells an agency to act, then we can sue them if the agency fails to carry out its congressional mandate. Okay, so why do we care about regulations and the rulemaking process? Well, the biggest reason we should care about regulations is because most laws are actually regulations that are issued by agencies and not statutes passed by Congress and signed by the president. During the period of time that the 114th Congress was in session, for example, Congress passed 329 statutes, while executive branch agencies issued over 7,000 regulations. So that is a 22-to-1 ratio, regulations to statute. And many of those regulations impact our daily lives, often without our conscious awareness of them. But regulations are especially important to those of us who work in the government, or those of us who interact with agencies, because we're feeling that personal impact of regulations. And additionally, in some fields like environmental law or finance law, financial regulations, our federal and state systems are interwoven with layer upon layer of regulations that are there to implement policies that are set forth by Congress, but also by state legislatures. With that many regulations, sometimes they're fragmented or they conflict or they create additional problems for an agency. Now, sometimes that interwoven layer of regulations work together. They create a beautiful tapestry of administrative law, but oftentimes it's kind of a tangled web of confusion instead. I want to reiterate that regulations and administrative law more generally, they are like the matrix. They are all around us. They impact our lives, even though we rarely think of them or notice them. So on the screen are just a handful of regulations that affect our lives or portions of our lives, often on a fairly regular basis. So we've got emergency response, 44 CFR 206.35. That sets forth the process by which states can request the president declare an emergency. We have seen this recently with the COVID-19 pandemic. All 50 states, DC, and 4 territories have issued major disaster declarations. And that's in addition to the nationwide emergency declaration that President Trump issued on March 13th, 2020. Electricity, 10 CFR Part 429 requires that commercial products meet certain energy conservation standards. We've got transit safety, 49 CFR 395.5 limits the number of hours that bus drivers or drivers of other passenger carrying motor vehicles, how long they can drive, which is typically they can't drive more than 10 hours, and that can only be after 8 consecutive hours off duty. We've got regulations about wildlife, wildlife refuge. You can enjoy recreational activities at our national wildlife refuges, thanks to the CFR. We've got endangered species regulations, for instance, protecting the Florida panther by listing it as an endangered species. We've got things like safe drinking water in airplanes. The CFR requires that airlines test their water for E. coli pursuant to the Safe Drinking Water Act. So here are a bunch of just regulations that touch our individual, often daily lives. And if none of those touch your lives, I'll bet this one does. So this is a fun one. Time. NIST, the National Institute of Standards and Technology, sets the official time for the United States via its atomic clock. And there is a regulation in the CFR that requires NIST to set standard time intervals and issue time corrections. So you can go to NIST's website at time.gov for the official US time. And it will even tell you whether your device's clock is off and by how much. So when I took this screenshot, my computer's clock was off by just under 2 seconds. So we care about regulations because regulations benefit us as individuals and they can benefit society as a whole. First, let's focus on how regulations benefit the law and the federal government. So we already know that it's impractical to expect Congress to apply the level of expertise and detail required to carry out a law. So regulations allow agencies to do what Congress can't, which is add that scientific expertise, industry-specific expertise, and key implementation details. So many statutes, especially ones dealing with complicated issues like the environment or the financial sector, they require a significant amount of scientific or other technical expertise. So it makes sense to let agencies add this expertise because agencies are supposed to be staffed with non-political personnel who are experts in their fields. Agencies are also inherently more flexible in regulating than legislatures are in passing statutes. Agencies typically can gather data, apply that internal expertise, and issue a regulation much faster than Congress can create a law. So this is especially useful in responding and adapting to rapidly expanding or rapidly changing circumstances. Sometimes agencies are even innovative. There is a lot of really interesting research going on within most agencies, from industrial hemp research at state agricultural departments to COVID-19 vaccine research at NIH and CDC, to some really futuristic stuff that goes on within the Department of Energy and the Department of Defense in their advanced research project agencies. Regulations also benefit society as a whole by preserving, to some extent, the public health and welfare, both physical and financial. Also by increasing public knowledge and creating consistency for individuals and organizations. So on average, our water is generally safe, our bank accounts are generally insured, our cars are more efficient, we know approximately how many calories are in the Big Mac that we want to eat, and our companies know approximately what's expected of them from a regulatory perspective, and that allows them to plan for the future. So all of these are generally useful things for society. So think about the part in A Fighting Chance where Elizabeth Warren talked about the Consumer Product Safety Commission and toasters. She says that back in the day, you had to be careful with toasters because they did not have an automatic shutoff function. If you forgot about your toast, the toaster, or both could catch fire and burn down your house. Today, it is almost impossible to buy a toaster that can just burst into flames if you leave it alone too long. And the main reason is because the US government, via the Consumer Product Safety Commission, monitors consumer products, things that we buy, for basic safety. So we don't have toasters that catch fire. We don't have lead paint in children's toys. We don't have baby seats that are dangerous in collisions. We don't have cars that lack functioning brakes, so on and so forth. The Consumer Product Safety Commission estimates that regulations, it's the standards that it promulgates, for cigarette lighters, cribs, and baby walkers save American consumers more than $2 billion a year, in addition to preventing untold numbers of deaths or serious injuries. What many people fail to understand is that there aren't just costs of taking action, but there are also costs in refusing to act. So, if the Consumer Product Safety Commission refused to act, we would have a lot more house fires from toasters, and that would be more expensive than just having automatic shutoffs on toasters. So unfortunately, the costs of inaction are often borne by the public, and also by portions of the public who have less say in the political process because of either systemic discrimination or their poor economic position. So with these poor communities and communities of color often take the brunt of the cost of government inaction. And that is not intentional, but it is still problematic on the ground. So I personally live in a minority majority county, and so I have witnessed this firsthand, especially in the terrible environmental conditions in and around our public schools. So regulations can benefit society. They also provide a benefit to industry. Companies and other regulated parties that want to do the right thing for their consumers, for society, for the planet, they benefit from having an even playing field. Not providing that even playing field kind of amounts to a subsidy that favors large multinational companies over smaller national companies or local companies. So good regulations allow good business to thrive because it creates the level playing field, it provides a guarantee of consistency in regulation, and that allows companies to plan for the future. And I like this quote from Joseph Kennedy Sr. He says, "Everybody says what business needs is confidence. I agree. Confidence that if a business does the right thing, it will be protected and given a chance to live, make profits, and grow, helping itself and helping the country." And that's what we hope to achieve with regulations. Now, sometimes we can literally see the benefit of regulations. Here are before and after photos of Los Angeles and Denver. You can see how much the air quality in both cities improved between the 1980s and the mid-2010s. And this visible benefit is because of the Clean Air Act and its implementing regulations. So even though we haven't eliminated all air pollution, we are breathing air that is cleaner than it was before, and we can see that difference that regulation makes. Here are two other specific examples of the benefits of regulations. This time we're going to focus on the Consumer Financial Protection Bureau. So first, the CFPB has taken specific steps to protect military personnel and veterans. Just this summer, July to September 2020, the CFPB brought a number of cases against mortgage companies that were engaged in deceptive practices related to Veterans Affairs guaranteed mortgages. So the CFPB did this sweeping investigation, looked at that particular slice of the mortgage industry, and decided to enforce laws that protect service members, veterans, and their spouses by, again, ensuring a regulated playing field for mortgages. The CFPB found that these mortgage companies were misleading customers by sending inaccurate mailers, like the one that you can see below left on the screen. They would, for instance, refer to a rate as fixed when it was actually adjustable. They would misrepresent their fees, create the false impression that they were affiliated with the military, etc. So to date, the CFPB has ordered 8 of these mortgage companies to pay a total of more than $2.6 million in civil penalties and then comply with various provisions for injunctive relief. So basically forcing them to come into compliance with the law. And the CFPB says that this is an ongoing effort, so we will probably see more enforcement actions on the way against these mortgage lenders and brokers. Second, the CFPB is making an effort to regulate mobile payments. Between 2010 and 2018, the U.S. investments in financial technology, or fintech, grew to about $100 billion, up from $2 billion. So that's in less than a decade. And a lot of that increase just actually took place in 2018. So mobile payments like PayPal and Venmo are really the most significant payment innovation that consumers have seen since credit cards. And over the past 5-10 years, they have evolved from kind of dubious apps that your parents would warn you not to use to part of the mainstream financial system. And mobile payments are becoming the primary payment option that we use in online commerce. So regulators have responded to the risks of consumer losses when using mobile payment systems by improving protections and regulations. So basically, they are doing the same thing, traditional safeguards. They're imposing the same traditional safeguards that protect our debit cards and our credit cards against losses. So now we actually have some legal recourse if we use a mobile payment system and we lose funds. So that's just part of the way that the CFPB is attempting to protect veterans, but also American consumers in general. While I think that regulations, particularly well-researched, well-drafted regulations, are generally a good idea because they create that fair playing field, there are most certainly drawbacks to regulations. So first of all, regulating for the sake of regulating is just not appropriate, in my opinion. Regulations need to be as clear as possible, as narrowly drafted as possible, and basically provide the best bang for our buck, both socially and economically. Unfortunately, a lot of times, because of the way that they are drafted or implemented, regulations can create delays and they can definitely add to the bureaucratic red tape. They don't have to, but people are right to be concerned about this drawback because it's a legitimate concern. Now, some of the delays are due to the need to put the regulation on hold while the agency and regulated parties fight it out in court, but sometimes those delays and red tape are really just baked into the regulation from the start, thanks to poor drafting or maybe confusion about what the agency was supposed to accomplish. One oft-cited argument against regulations is this concern about creating a nanny state. And again, this is in part a legitimate concern. We don't want the government dictating our every action. However, a lot of regulations, and we could take California's Proposition 65, which you'll see warning labels on various products about Prop 65. A lot of these regulations are now aimed at requiring public disclosure rather than forcing companies to make any changes in their products. So for these types of regulations, we don't really have to worry about a nanny state because the regulations don't stop the public, us, from accepting risks or making bad choices. The regulations just make the terms of the deal clear so that we can make an informed choice. I know that it's not a great idea to eat a Big Mac, but I eat Big Macs now and then, and I know how many calories are, and I'm making that decision. Another concern is that regulations can be costly for business. Agencies should attempt to make sure that any upfront costs are eventually going to result in benefits to the regulated business, but it's never guaranteed. However, on the whole, we do find that the cost of regulating is far less than the cost of failing to regulate appropriately. So the cost of regulating air pollution or financial products is less than the cost of allowing unchecked pollution or another financial crisis. In addition to being costly, there are concerns that regulations can put companies out of business and inhibit innovation. So for instance, by scheduling industrial hemp, which has less than 0.3% THC, but by scheduling hemp as a Schedule I narcotic for decades, the federal government has really long held up important innovations in farming, ranching, textile manufacturing, and medications. And in that case, those regulations didn't just put companies out of business, they didn't allow business to get started in the first place. Now, fortunately, this has changed. You have probably noticed products containing CBD oil are everywhere. So companies, they want to compete fairly for customers, then they should be happy about regulations that enforce fairness and transparency. Because an honest company can't compete with a company that's willing to be dishonest with consumers. Now, something that is not cited very frequently, but certainly a concerning drawback of regulations, is that the feds often rely on state governments to carry out a lot of the implementation work. And state governments don't necessarily have the resources to properly implement those regulations. So finally, kind of to sum up the drawbacks, poorly drafted, poorly thought out regulations are, not surprisingly, a bad deal for all of us. They burden regulated parties without providing any real value to the public. But these regulations don't have to be poorly drafted or poorly implemented. If we use agency expertise appropriately, and if we take all stakeholders into account, then regulations should work for the benefit of everyone. So as I mentioned in our government contracting lecture, I love government-sponsored research programs. They provide an incredible return on investment for the American taxpayers. I've been super lucky to provide legal support to some really amazing scientific programs, from the Cassini mission to Mars rovers, to this quantum computing lab where I was actually able to see a single atom with my bare eye because they had it fluoresce. So I've supported things like honeybee research and sustainable agriculture and clean water research, and conservation efforts in the Great Lakes and the Chesapeake Bay. And that's just a tiny sliver of the government-sponsored scientific research that has or will directly benefit the public. But how does the government tap into this scientific expertise when creating policies and regulations? Well, typically, Agencies create scientific advisory committees to help, or Congress creates the scientific advisory for the agency. According to the GAO, these advisory committees play a very important role in the development of policy and government regulations. Now, it's important to understand that these science advisory committees do not make policy. Their job is to explain what the science or the data says about the likely consequences of policy choices. Then it is up to the policy makers, within the boundaries set by the law, to use that scientific and technical advice to make the best decision. And policymakers often face situations, from epidemics to natural disasters to national security threats, in which the effective use of scientific information can have a really big beneficial impact on public health and safety. So to meet those challenges, agencies need the advice of independent scientists who can provide objective expertise. Hence, we have science advisory committees. There are around 1,000 of them, boards or committees. They are typically governed by the Federal Advisory Committee Act, which is a 1972 statute that requires the government to keep a government-wide database that lets agencies use and manage these various science advisory committees. Also lets Congress perform oversight. The database is also searchable and available to the public. The Science Advisory Committee meetings themselves also have to be open to the public. The committees, they keep meeting minutes, they keep other records, and those are publicly available. These committees are governed by official charters, which have to be renewed every 2 years, and those charters dictate their missions, procedures, and meeting frequencies. And committee members are often academic or industry researchers who are near the top of their fields. They do not get paid very much, if anything at all, to serve on these committees. In fact, these committees are a great deal for taxpayers because taxpayer funds typically only reimburse some travel expenses. And of course, the feds don't allow you to get reimbursed for first-class travel. So like I said, there are about 1,000 of these scientific advisory committees throughout the federal government. Just a handful, we've got an advisory board on child abuse and neglect, an advisory committee on minority health. We've got a board of scientific counselors in the Office of Public Health Preparedness and Response. Looking at Colorado, we've got a Rocky Mountain Resource Advisory Council. So there are quite a number of these committees. The EPA has 22 science advisory committees, but the most important is its Science Advisory Board. So that board was created by statute in 1978. It was created specifically to provide scientific advice to the EPA. Today, the board is made up of 45 independent scientists, all experts in their field, all selected by the EPA administrator to advise the EPA on scientific and technical aspects of environmental problems. The Consumer Financial Protection Bureau also has research and advisory boards, the primary one being the Consumer Advisory Board. That was created by the Dodd-Frank Wall Street Reform Act. Its members are experts in consumer protection, financial services, community development, fair lending, and civil rights. And they are also, they've got representatives from depository institutions, so banks and credit unions, that primarily serve underserved communities. So now that we have covered the intended role of science and expertise in rulemaking, let's take a look at how things are going in practice. So unfortunately, in our current political environment, scientific research and advice has really come under attack. And this should be a grave concern to everyone, regardless of political affiliation, for a variety of reasons. So first and foremost, scientific research is a necessary element when it comes to solving complex problems. Doesn't matter if those problems are natural or man-made. For example, we need scientific research to understand and hopefully reverse climate change, which is a looming problem. We need science to understand the COVID-19 virus and hopefully get it under control. It is thanks to science that emergency planners and public health officials have a lot more information on hand when it comes to predicting and mitigating the effects of earthquakes, volcanic eruptions, hurricanes, and even epidemics like Ebola and COVID. So science is far from perfect, But the great thing about it is that it is not stagnant and it's not invested in the status quo. It changes in response to newly discovered evidence. So I firmly believe that science and government should be walled off from politics because it impacts all of us. Hurricanes, fires, natural disasters, they don't limit themselves to red or blue areas of the country. COVID-19 doesn't only infect Democrats or only infect Republicans. But unfortunately, science has become really politicized in our current environment. Now, when I say current, I do mean the past couple of years, which have been quite unusual from an administrative law perspective, but I also mean just the past couple of decades in general. As just one example that affects science advisory committees, in June of 2019, President Trump issued an executive order that required all federal agencies to evaluate the need for each of their current advisory committees. So the order gives agencies until the end of September 2020 to terminate at a minimum 1/3 of their agencies, or of their committees, sorry. So agencies have to go through their science advisory committees and get rid of at least 1/3 of them. Now, this is not the first time such a cut has occurred. Bill Clinton made a similar cut back in the early 90s, reducing any committee that wasn't required by statutes. But that was after a government-wide review of the federal bureaucracy. The cuts under the Trump administration have been more arbitrary because they're not the result of a review that turned up any problems. And as the New York Times article that we read this week points out, clashes over the use of science and policymaking, these occur in all presidential administrations. Doesn't matter if they're Republican or Democrat. But these clashes between science and policy have become much more dramatic over the past couple of years. One of these clashes that we read about this week comes from the proposed Strengthening Transparency in Regulatory Science Regulation, which specifically impacts the EPA, although I imagine that we will see something similar in other agencies unless we pull back on our current scheme of deregulation. So this transparency in science regulation requires that the EPA make raw data behind its research publicly available in order to be considered during the EPA rulemaking process. If there is no publicly available data, they can't use it to craft a regulation. So on its face, that seems like maybe it's okay. But unfortunately, this regulation reaches all the raw data, and that includes things like individual medical records and other confidential data. And the problem, of course, is that there are other federal laws that prohibit the government from disclosing individual or confidential or proprietary data publicly. So because we've got these federal laws that prohibit disclosure, the EPA researchers legally, they can't disclose that raw data. And under this proposed regulation, if the EPA cannot disclose all of this raw data, then that research can't be considered during the regulatory process. Now, EPA Administrator Andrew Wheeler has said that this rule is necessary because good science is science that can be replicated and independently validated. And he is totally right about that. We do need to check, and we need to double check scientific evidence upon which regulations are built. But that already happens. Scientific studies are generally not considered valid unless they can be replicated. And so what this indicates is that this transparency in science regulation is not actually about transparency in science, because that already exists for publicly funded research, but more about shutting scientists out of the regulatory process. And that's the concern that led to the EPA's Science Advisory Board pushing back really strongly against this particular regulation. And remember, the EPA's board is composed of scientists who were named by Trump's past 2 EPA administrators. So it's not like this is a liberal think tank pushing back. These are people named by the Trump administration who are disagreeing with the Trump administration's EPA regulation. Members of the public and other organizations impacted by EPA research have also pushed back really strongly, and the EPA decided to make some modifications to the proposed rule. It extended the comment period. That comment period closed in May. They had almost 1 million comments. That might be one of the most commented upon regulations ever. The EPA has not yet issued the final version of the regulation, so we are still waiting to see the impact. We have also, of course, seen the sidelining of science during the COVID-19 pandemic, where politics have trumped public health guidance, no pun intended. This is not a regulatory issue, but it's worse because it's a public health crisis where the federal government, particularly the CDC, should be taking the lead in battling the coronavirus. But unfortunately, those scientists have been kind of pushed aside by political appointees. All right, let's turn to the concept of regulatory reform and its recent history. So because there can be drawbacks to regulations, especially ones that have negative consequences for the economy, there is always a desire for regulatory reform. That's often framed in political terms, but at its core, it is a neutral concept. As our government expanded, so have its tangles of laws and regulations. And not every regulation is good or necessary because things change. And we shouldn't keep regulations that are not beneficial to us, either the public and or industry. So a regular review of regulations to catch and remove outdated ones, or ones where the benefits haven't materialized, that is a good idea. And that was the point of the Regulatory Flexibility Act, a 1980 statute whereby the federal government tried to balance the socioeconomic goals of federal regulation with the needs and capabilities of small businesses. So the origins of the Regulatory Flexibility Act can be traced back to the discontent over the federal regulations. That businesses were expressing this discontent, starting with the New Deal, moving onward. And as more and more agencies were created and given fresh mandates to pursue in the 1960s and 70s, suddenly these concerns kind of increased sharply, and Congress passed this Regulatory Flexibility Act. So the act requires the federal government to solicit input from small businesses and other small entities, including nonprofit groups, and to seek less burdensome alternatives for those small entities whenever possible. A year after Congress passed the Regulatory Flexibility Act, President Reagan signed an executive order that required the Office of Information and Regulatory Affairs to review regulations that have an annual economic effect of $100 million or more, and or might have an adverse impact on the economy, productivity, jobs, the environment, and public health or safety. In 1993, the Clinton administration revoked Reagan's executive order, but replaced it with a very similar executive order, basically adhering to the same principles, including a review of any regulations expected to have an annual economic impact of $100 million or more. Like Reagan's order, Clinton's executive order was premised on the idea that federal agencies should use regulations only as required to carry out the laws enacted by Congress, or as required to protect the public. And Clinton's order actually included environmental law aspects of protecting the public health and welfare. A few years later, in 1996, the Republican-controlled Congress passed and Democratic President Clinton signed the Congressional Review Act. The CRA allows Congress to engage in an expedited review of any new federal regulations and allows Congress to overturn those regulations by passing a joint resolution within 60 legislative days from the date the regulation becomes effective. If Congress uses the Congressional Review Act to strike down a regulation, the act prohibits an agency from reissuing a substantially similar regulation unless Congress specifically authorizes it through a subsequent statute. So what that means is that 51 votes in the Senate can repeal a regulation, but 60 votes might be needed for the repealed rule to go into effect again, because legislation containing the second version would be subject to a filibuster. And so this is why some people refer to the Congressional Review Act as the kryptonite of regulations. Pay attention to this concept of legislative days, too. It is important. Congress is not in session every calendar day or even every business day. So by saying 60 legislative days, the Congressional Review Act gives Congress a real decent amount of time to review and revoke regulations. Now, until quite recently, the CRA was rarely used. It was a congressional check on executive branch agencies. But it wasn't triggered very often because there's not much point in using it unless there is a change of political control in Congress or the presidency. Presidents, as you might imagine, really don't want to overturn their own administration's regulations and will lobby Congress hard. So the Congressional Review Act is most often used now to overturn the last regulations of a presidential administration on its way out. And that's what Congress did during the change from the Obama administration to the Trump administration. So prior to that session of Congress, prior to the 115th Congress, the Congressional Review Act was only used successfully one time since 1996. There have been over 73,000 regulations that it could have overturned, but they was only used to overturn one. Then the 115th Congress comes into session, and it used the Congressional Review Act 16 different times to roll back Obama administration regulations, particularly environmental regulations. The best known of those rollbacks was probably the Stream Protection Rule. That was in the works for about a decade. There were massive amounts of input from scientists, industry, and the public. And the Stream Protection Rule was trying to implement a statute from 1977, the Surface Mining Control and Reclamation Act. The Stream Protection Rule was trying to protect our nation's waterways from debris generated by surface mining. The Department of the Interior said that rule would protect about 6,000 miles of streams and 52,000 acres of forest by keeping mining debris away from nearby waters. Now, the Stream Protection Rule was far from perfect. For starters, it was 1,200 pages long, so that's not going to be a breeze to implement. But it was designed to balance environmental protection and the nation's need for coal as a source of energy. And generally, it was thought to have as limited an impact as possible on the coal industry. So it took 15 years of effort to get that Stream Protection Rule in place. And all of that effort, including environmental justice impact surveys of nearly 300 coal-producing counties, all that effort was wiped out by Congress using the Congressional Review Act. And since Congress revoked the Stream Protection Rule, it's unclear how the federal government will be able to implement any of those requirements of that Surface Mining Control and Reclamation Act. Again, these are requirements that should have been in place since the late 70s. We finally got around to putting them in place, only to have them struck down. And now Congress has to explicitly authorize the EPA or other agencies to create that rule again. Another piece of regulatory reform is Executive Order 13771, signed by President Trump in February of 2017. So this order created a task force and a regulatory reform officer at each agency. Basically, those were responsible for combing through existing regulations and determining which ones should be repealed or modified. So far, so good. That should really be a standard operation within agencies. Unfortunately, this executive order also requires that agencies repeal 2 regulations for every 1 regulation they create. This kind of creates a ridiculous conundrum for agencies and for the public. So say the EPA wants to issue a new regulation on clean drinking water. Is it going to have to give up 2 regulations about clean air? If the Consumer Financial Protection Bureau wants to issue a regulation addressing a new financial scam, is it going to have to repeal regulations protecting the public from older financial scams? This is just it's not possible to offset regulations like this or even to compare regulations because it can be an apples and oranges comparison. This executive order also requires the total incremental cost of all new regulations to be $0. That is almost impossible because eliminating a regulation triggers the same process as creating a regulation. So that is a time-consuming, potentially expensive requirement for any new congressional legislation or any new agency regulation on a wide variety of topics, from banking to the environment to healthcare to labor laws to space exploration. Additionally, our regulations are supposed to be issued and repealed based on scientific evidence, not just the sheer number of them. The Brookings Institute's tax and fiscal policy expert, William Gale, actually said that. He came out and said the number of regulations is not the key, it's how onerous the regulations are. And he said that this particular executive order seems like a totally nonsensical constraint. And historically, we have not done a very good job when it comes to properly implementing regulatory reform. Instead of a graduated reform, we instead deregulate entire industries and then kind of let them run wild. And Elizabeth Warren covers this in A Fighting Chance. She notes that in the financial realm, the US has gone through far too many boom and bust cycles as the federal government regulates and then deregulates the financial industry. This started back during the gold rush. It continues up through today. Today, our country, especially older millennials, still feeling the impact of that 2008 financial crisis. So in this cycle of regulation and deregulation, something goes wrong in the financial market, companies and individuals lose a ton of money, so the government steps in to regulate. Then, based at least in part on those regulations, the financial market improves and people regain trust in it. And then the regulated parties start to complain about the burdensome regulations, and the government deregulates, trusting the financial industry to police itself. But the industry doesn't follow through, and then once again something goes wrong, and companies and individuals lose tons of money, and that cycle begins anew. And there is no reason why we have to keep going through boom and bust cycles with financial regulation, and really no reason that we should. And the same is true of other regulations, such as environmental regulations. We effectively had no environmental regulations until the 1960s and 70s. At that point, the government suddenly realized that industry was endangering the public health and welfare, and so it started regulating. But as the environment improved, think back to those slides of LA and Denver then and now, companies started to complain about the regulations. The government started backing off, again assuming that agency was going to regulate itself. And sometimes industry does regulate itself, but often it does not. So petroleum companies like Exxon, for instance, have admitted in writing that they knew the science behind climate change, and they knew that they were harming the environment as far back as the 1970s. And for decades, these companies did nothing to mitigate the damage that they knew they were causing. And worse, they actively hid that damage from the government and the public. So recently, the EPA has rolled back 95 environmental regulations. Even more recently, the Consumer Financial Protection Bureau, it's in the process of rolling back its payday lending regulations. But we have to wonder, those rollbacks, what do they cost society? A professor at Harvard School of Public Health estimates that the environmental rollbacks could lead to 80,000 extra deaths per year and respiratory problems for 1 million people. Those are unnecessary deaths. Those are unnecessary chronic conditions. They don't have to happen. So we need economic, regulatory stability for the benefit of our nation, for its people, and its businesses. We need to learn from history and from the expertise that our federal government and our industries have built up over the years. Okay, enough with benefits and drawbacks of regulations and regulatory reform. Let's take a look at the actual process that gives us regulations, since they are not dropped off by a stork. So rulemaking is the exercise of an agency's quasi-legislative authority, and it is through that rulemaking process that agencies promulgate regulations. During the process, agencies are seeking to fill those gaps left by Congress in the statute. Agencies cannot create these regulations, kind of willy-nilly. They've got to follow procedures set forth by Congress in the Administrative Procedures Act. Also, if an agency has established additional procedures for its rulemaking, it's got to follow those additional procedures. They are not required, but if an agency sets the rules, then the agency's got to play by those rules. So since rulemaking is the process used to create regulations, let's take a closer look at the process itself. So very basically, Congress enacts a statute that tells an agency to create a regulation. The agency takes some time to analyze the law, needs to understand what regulations it should issue. Then the agency issues a proposed regulation for public feedback. It takes that feedback into consideration, and then it issues a final regulation. So that is a very high-level view of the process, but in practice, there are a lot of steps. So there are steps that agencies take before they start drafting a regulation. First, they analyze the law, and they decide how to allocate limited resources to implementing that law via regulations. In doing so, agencies first have to evaluate the various problems that face them. And I say problems, plural, because the agency's got to solve the problem handed to it by Congress, the one that it's supposed to solve by issuing the regulation. But agencies also have to look for future problems that might result as a consequence of any new regulation. Second, agencies have to evaluate their resources, decide how much time, money, and personnel are available, not just to draft the new regulation, but also to enforce it. Third, once the agency's got a resource allocation plan, it's got to decide exactly what to regulate, where to regulate, when to regulate, and how to regulate. And only then can the agency draft its proposed regulation and move on to what we call the notice and comment period. So let's take a closer look at this pre-drafting process as it relates to the Consumer Financial Protection Bureau. Okay, so Congress instructs the CFPB to regulate consumer financial products. The CFPB first has to figure out exactly what that means. What does Congress want the agency to regulate? That authorizing statute might not explicitly state a list of financial products that require regulation. So it is up to the CFPB to figure out which of those products to regulate. Agencies also have to consider re-regulating as they accumulate more data, as scientific and technical tests are improved and refined. So it can cost a lot of money and take a lot of time for an agency simply to gather data on impacts of, say, debt collectors or student loan companies, or anything else they need to regulate. Agencies that face complex, multifaceted issues need to engage in a lot of research and planning to address those issues. The agency also has to determine whether to focus on a specific product first, or generally how to prioritize. So once the CFPB understands or thinks it understands what it should regulate, it then has to decide how much to regulate. The CFPB can't just ban consumer financial products because that would kill our economy. That would not benefit anyone. So instead, the CFPB's got to figure out how much fine print is okay. Is this fine print well understood by the public? If it's not, how much damage might that do to the public? After the CFPB answers the what and how much questions, it has to determine on what basis to regulate and then how to regulate most effectively. The Dodd-Frank Act, it's a massive piece of legislation, and it has produced massive numbers of regulations. So which part should the Consumer Financial Protection Bureau address first? Or instead, should they focus on consumer complaints or feedback from the advisory board or feedback from the agency's own internal research teams? They also have to look at what policy options are available. How much do those options cost? What is the cost of not regulating a particular area? So if you think about our financial crisis of 2008, from a purely financial perspective, the cost of the federal government not regulating subprime mortgages and other new financial products in the early 2000s, that has cost the nation about 15% of our gross domestic product, $4.6 trillion, trillion with a T. A 2018 study by the Federal Reserve Board found that that financial crisis has cost every single American about $70,000. It cost you $70,000. It cost me $70,000. It cost our friends $70,000. So agencies have got to weigh the cost of various policy options, including the cost of not regulating, and decide which best meets the agency's mandate. Now recall that agency actions can be formal or informal, but that the vast majority of agency action is informal. If a statute specifically requires an agency to engage in formal rulemaking, the statute is going to say so. It is going to use the magic words on the record after an opportunity for hearing. If you do not see those magic words in the statute, the agency is not required to use formal rulemaking. So that means that the vast majority of agency rulemaking is informal. It follows a notice and comment process. So once the agency has proposed a regulation, it publishes it in the Federal Register, and it allows for public comment. I think that this notice and comment period is one of the really cool aspects of rulemaking, because we, the public, can get really involved. I actually view rulemaking as our #1 chance to interact with the federal government. So why rulemaking and not voting? You know, voting is incredibly important. Please vote. But that only happens every 2 years at the federal level. On the contrary, rulemaking happens all the time. And rather than just cast a single vote, you can actually provide substantive feedback to the executive branch. So that's why I think that this is a great opportunity for public involvement in government. And some agencies get the public involved from the get-go. They will issue an advance notice of public rulemaking, and they'll listen to public input before they even start drafting the proposed regulation. That is more rare, though. Usually, we've got the chance to provide feedback after the agency issues its proposed regulation in the Federal Register. And the Administrative Procedure Act, it requires that agencies actually read and respond to public comments on proposed regulations. The agencies can group these comments together, similar comments together, to provide a consolidated response, but an agency has to respond to all substantive issues that are raised by the public, and it has to explain its reasoning. On the screen, the left image, that is a final regulation issued by the Consumer Financial Protection Bureau. It gives a section by section review of the regulation and the public comments submitted about each section of that regulation. The right image, that's a quick overview of the comments that were received in response to the EPA's Strengthening Transparency in Regulatory Science proposed regulation. I said it was almost 1 million. You can see there 993,460. So agencies, they can revise a proposed regulation in response to comments. They're not stuck with a single draft and then a final. They can issue multiple drafts. And for each draft, the public gets another chance to comment on the proposed draft. So this back and forth between the public and the agency, it creates a permanent record that is very useful in understanding the background of the regulation. You can think of it kind of like the regulatory version of legislative history. So after the agency reviews public comments, it drafts the final version of the reg, publishes it in the Federal Register. The agency also has to publish information about the facts that it relied upon when issuing the reg. It's got to define any major policy areas that the regulation will impact. And as I said, it's got to respond to public comments. The final regulation becomes valid and enforceable 30 days after it's published in the Federal Register. This 30-day period gives the regulated parties time to get ready to comply. Now, an agency can decide to withhold enforcement for a longer period of time, particularly for more burdensome regulations or regulations that require technical changes. Agencies want to give individuals and organizations, especially businesses, extra time to come into compliance before the agency starts enforcing the new regulation. This also allows time for a legal challenge to the regulation through the courts. So compliance can be very complex and expensive, so it's only fair to give regulated parties time to figure out what's expected of them, whether their actions are going to be lawful, and how they can best comply. So agencies can delay that compliance period, but most regulations are going to go into effect 30 days after they are published in the Federal Register. I would be remiss not to at least mention that there are actually multiple types of rulemaking, but really and truly, plain old informal notice and comment rulemaking is the default, it's the norm. Formal rulemaking, again, it occurs when the statute uses the magic words on the record and after an opportunity for hearing. So, for instance, if you need to talk about rulemaking for one of your memos, you're going to need to take a look at the controlling statute and see if it contains those magic words. If it doesn't contain the words on the record and after an opportunity for hearing, agencies are going to go the informal route. Agencies do not choose to engage in formal rulemaking on their own, and that's because it is expensive and time-consuming. So the formal rulemaking process requires an evidentiary hearing, basically a mini trial. You can have cross-examination of expert witnesses, the whole shebang like you would see at a court trial, and that culminates in the hearing officer's opinion, which is the executive branch version of a court opinion. This is just another way that agencies have a separation of powers issue. So anyway, as you can imagine, those additional steps, these added procedures, are costly, and so agencies prefer to use the informal notice and comment style of rulemaking unless the statute says otherwise. Now that said, Congress or the president, but not the courts, can require agencies to use what we call a hybrid rulemaking process. In reality, this is still the informal notice and comment process. It just includes one or more added elements. So usually, the hybrid model is notice and comment plus a decision to hear maybe oral comments instead of just written ones, or a disclosure of some type of methodology or disclosure of raw data, that supports the agency's proposed regulation. There is a specific model called negotiated rulemaking, which we'll discuss in a moment. There is also exempted rulemaking, which is neither formal nor informal, and it does not require any public involvement. But exempted rulemaking is only available for very select issues, such as internal agency operations. And in exempt rulemaking, those resulting regulations do not impact members of the public. There are no regulated parties, and that's why there doesn't need to be any public input. So there's this hybrid model known as negotiated rulemaking, sometimes called neg-reg or reg-neg. This form of rulemaking brings together groups of stakeholders with the goal of drafting the regulation by consensus. So agencies that are using negotiated rulemaking have to provide a significant amount of administrative information and substantive information. That includes proposing committee members. Those committee members have to be drawn from a pool of impacted parties. The agency's got to propose detailed meeting agendas. So once it gets a negotiating committee in place, it selects a public policy mediator to facilitate the negotiation process. So it's got an independent, neutral mediator, and it's got a group of stakeholders from all of the regulated parties. And the negotiation process typically takes from 6 months to 1 year. It is open to the public. So again, negotiated rulemaking, it is an informal notice and comment plus putting together this negotiating committee. So agencies can choose to use negotiated rulemaking. Both the EPA and the Consumer Financial Protection Bureau use it. So do other agencies, off the top of my head, USDA and OSHA. Regulations that are made via this negotiated rulemaking process are usually more practical and easier to implement and enforce, and that's because the regulated parties were at the table and helped shape the regulation. Now, there are concerns that industry is able to dominate, negotiated rulemaking to the public detriment. And it is certainly easier for large companies to participate in these negotiating committees. But I'm not sure that we need to be any more concerned about negotiated rulemaking than any other type of rulemaking, because industry and special interest groups, from all across the political spectrum, tend to dominate the rulemaking process in general. But that's because we, the public, don't usually submit public comments. So please think about submitting some public comments in response to a draft regulation. Now, because agencies have to submit almost all of their regulations to the public for feedback, and because those regulations have the force of law, it is not easy for agencies to revoke those regulations. So because everything went through public comment, the process for an agency to unmake or revoke a regulation is basically the same as the regular rulemaking process. Agencies have to go through all the same steps. They've got to publish a draft revocation in the Federal Register, request and respond to public comments, publish the final revocation in the Federal Register, and then wait 30 days before revoking the regulation. Now, if this is just for older, outdated regulations, it's not a big deal because there's not going to be a lot of public feedback clamoring to keep an outdated regulation. But if they revoke newer regulations, then the agencies do have to go through that whole process, and it can be contentious. The courts and Congress have other options to unmake regulations. As we saw, Congress can use the Congressional Review Act, or Congress can pass a law that effectively overturns a regulation. Courts can strike down regulations that they find unconstitutional or otherwise in violation of federal laws. Now, after an agency issues a regulation, it's supposed to enforce it. And a lot of these enforcement decisions are left to the agency's discretion. So agencies can serve administrative warrants, which we'll discuss a little bit later this semester. Agencies can audit, investigate, levy fines, adjudicate offenders, and also sue offenders in court. And through levying fines, revoking licenses, and taking other actions, agencies can sort of punish individuals, companies, or other organizations that violate a regulation. But agencies don't have to focus solely on punishment. They can offer carrots instead of using sticks. So agencies will sometimes offer economic incentives to make compliance more palatable for the regulated parties. As I said earlier, enforcement is usually administered in collaboration with state governments. And sometimes that's fine. Sometimes states are willing collaborators and partners, but sometimes states have divergent interests or are focused on something that they consider to be more pressing. The courts are also able to enforce regulations through the judicial review process. When it comes to enforcing regulations in real life, sometimes it can be easy, and sometimes enforcement requires a lengthy battle through the court system. And so with that in mind, let's turn to the never-ending drama of the FDA graphic cigarette warning labels, which has been ongoing since 2009. So in 2009, Congress passed the Family Smoking Prevention and Tobacco Control Act and required that cigarette packages and ads have larger, more visible graphic health warnings, not just the text-based warnings that we have had for decades. So in 2009, Congress gave the FDA 2 years to come up with regulations requiring that tobacco warnings contain color graphics that depict the negative health consequences of smoking. Per the act, the FDA should have issued its final regulations by June 22nd, 2011. So the FDA issued its proposed regulation in November of 2010. It received over 1,700 comments, which is really quite a lot because not every regulation can grab the public attention the way that, say, the Transparency in Science regulation did. In any event, the FDA issued its final regulation on June 1st, 2011, ahead of the deadline set by Congress. So the FDA started well. Its final regulation was set to go into effect September 1st, 2012. That regulation was based on a fairly extensive review of scientific literature, as well as the results of an 18,000 person study, plus those 1,700 or so public comments. And the FDA provided specific examples of warning labels that companies would need to adopt, and you can see some of them here. Even though it issued a regulation, the FDA never took any actions to enforce it, and that was in part because of lawsuits. On August 16th, 2011, 5 tobacco manufacturers, including the lead plaintiff, R.J. Reynolds, filed suit against the FDA in U.S. District Court for the District of Columbia. They challenged the FDA's graphic warning rule. And those companies argued that the rule violated their First Amendment rights and that the warning label requirement should be put on hold until the case was finally and fully resolved. The district court agreed, and it blocked the FDA's graphic warning regulation on a First Amendment compelled speech basis. So the government cannot restrict our free speech, but the government also cannot compel us to speak in a certain way. That compulsion would be a violation of the First Amendment. So the FDA appealed the district court's decision, but the D.C. Circuit Court, that is the Federal Court of Appeals for the District of Columbia Circuit, affirmed the district court's decision. Although those circuit court judges who hear appeals together, much like the Supreme Court does, it's en banc, they were not unanimous. So this appeal dealt mostly with the actual images the FDA selected. It again focused on the idea that the government cannot compel us to speak in a certain way. Now, the government, as we have discussed, has more leeway under the First Amendment to regulate commercial speech, but the Court of Appeals held that the FDA did not meet the Administrative Procedure Act requirement to provide substantial evidence that the graphic warning labels would directly help the FDA meet its goal of reducing the number of Americans who smoke. So the court sent the case back, told the FDA to come up with different warning labels that would pass the free speech challenge. And at that point, the FDA did not appeal the ruling. It said that it would go ahead and issue a new regulation about warning labels in about a year. At the same time that the R.J. Reynolds Company was winning in the D.C. Circuit, the FDA was winning in the Sixth Circuit. So the Court of Appeals for the Sixth Circuit found that the FDA was obligated by law to implement some type of graphic warning label. Now, typically, the Supreme Court will take a case if there is a split in opinion, if there is a circuit split, and that's what we've got here. The D.C. Circuit and the Sixth Circuit, both courts of appeals at the same level of the federal judiciary, had reached different decisions. But in this particular case, the Supreme Court refused to hear the tobacco company appeals. That was in April of 2013. And that meant that the FDA was stuck. Should it issue the warning labels as required by the Sixth Circuit, or go back to the drawing board as required by the D.C. Circuit? Because the FDA refused to follow through on issuing a revised rule, in 2016, a group of organizations, including the American Cancer Society, but also the American Academy of Pediatrics, the American Heart Association, the American Lung Association, and several doctors, they decided to sue the FDA in the U.S. District Court for the District of Massachusetts. So we have now introduced another jurisdiction. And in this 2016 case, the plaintiffs took a different tactic. They alleged that by failing to issue those graphic warning label regulations, the FDA was unlawfully withholding action. And the plaintiffs argued that the courts could compel action through the Administrative Procedure Act. And that is because under the APA, federal courts can compel agency action that has been unlawfully withheld or unreasonably delayed. And the plaintiffs in this case contended that if the original law back in 2009, it only gave the FDA 2 years to create a final rule, there's no reason that it should take 4 years just to pick out photos. Additionally, the plaintiffs pointed to research that had been released in the years that had passed since the proposed regulation was issued, and it indicated that these new warning labels would have saved potentially millions of lives if they had been put in place in 2012. So it took a while, but in 2018, the District Court in Massachusetts finally ruled that the FDA had unlawfully withheld action. It had unreasonably delayed its final regulation on cigarette graphic warning labels. And the FDA told the U.S. District Court that it would finalize new warning labels by November of 2021. At which point the judge pointed out that that proposed date is a decade or more after the original deadline, and that because the FDA had already unreasonably delayed action for such a long time, the FDA had to present her, the judge, with an expedited schedule by late September of 2018. In August of 2019, the FDA finally issued another proposed regulation on the required graphic warnings for cigarette packages and cigarette advertisements. In November 2019, the FDA extended the comment period with comments due by the end of the month. Finally, in March of 2020, the FDA finalized its regulation. It's called Required Warnings for Cigarette Packages and Advertisements, and it established 11 new cigarette health warnings, some of which you can see on the screen. On March 18th, 2020, the FDA published its final regulation in the Federal Register. So where are the new graphic warning labels for cigarette boxes? It was published in the Federal Register March 18th. Normally it goes into effect 30 days later. However, on May 20th, 2020, the FDA published a notice in the Federal Register that delayed the effective date of the new regulation. Now, this particular delay does seem to be specifically related to the COVID-19 pandemic. The FDA has a statement on its website saying that it remains fully committed to the regulation and that it would not have agreed to postpone the effective date but for the extraordinary disruptions caused by the pandemic. So as of the date of this lecture, the new effective date for those graphic cigarette warning labels is October 16th, 2021, although the FDA is urging companies to submit their cigarette warning label plans by December of this year. So we will have to wait and see if this regulation, which again has been in the works since 2009, will actually take effect late next year. So stay tuned, we'll find out together. All right, that's it for this week. And the only thing that you've got due this week is your prospectus, super short statement of the topic you plan to cover for your policy analysis memo. Now your first assignment memo, M1, that is due at the end of week 8. I have opened up a collaborative discussion board for it. The fact pattern for M1 comes from the movie Limitless. That's about a new mind-expanding drug known as NZT. And so for the memo, you're going to pretend that you are a DEA employee and that based on the facts of the movie, you have been asked to develop regulations governing the classification of NZT. You can rent the movie on Amazon for about $3, or you can skip it entirely and rely on the written fact pattern. If we were meeting face to face, one of our classes would actually just be like a movie night. We would watch the movie together and discuss it. So I'm sorry that we can't do that, but do think about watching it. It's pretty enjoyable. Thanks for listening. I will see you on the non-graded discussion boards. Have a great week.